Hi, this is Professor David Opterbeck, and welcome to the next lecture in our new media law class. And in this class, we're going to be talking about the law relating to video games. Obviously, there's a lot we could talk about concerning video games. We could do a whole class, a whole semester, I think, just on video games. So we do have to focus our discussion on a few aspects of video games. I've chosen to do video games in this class because I do believe that when we talk about new media, video games are certainly one of those areas of media that is becoming increasingly important. And when we have talked about convergence, which we have talked about all semester, I think video games are a place where issues relating to convergence are increasingly becoming really important. And you'll see even a little bit of that in our discussion today about trademarks in virtual worlds, about the Digital Millennium Copyright Act in virtual worlds. I think you're going to see the structure of virtual worlds, games, activities that are in-game, out-of-game, media centers like the Xbox, which hasn't quite gotten there yet, but wanting to be the hub of all the communications in the household. All of these things are going to continue to be important themes. So what are we going to talk about in this class? We're going to talk about COPPA, which is the Child Online Privacy Protection Act. We're going to talk about ratings of video games and the First Amendment. We're going to talk about the Digital Millennium Copyright Act and virtual worlds, the in-game use of trademarks, and the copyright status of video game characters. And you'll see as we talk about some of these things that some of the law, as we'll talk about COPPA. I'm actually going to show you in a moment a video from the Federal Trade Commission that lays out a very nice summary of COPPA and its requirements. And that, of course, is a federal statute and a regulation related to the statute. When we talk about the First Amendment, we'll be looking at a U.S. Supreme Court case. So there we have some law that's established at a very high level. Some of these other cases we'll be looking at might be from one particular circuit or district court cases, and I think you'll see that some of the law in those areas potentially is in flux. So the first thing I'm going to do is I'm going to cut away from our presentation here, and I'm going to show you this video from the Federal Trade Commission relating to COPPA.
When it comes to information that companies collect online from kids under 13, parents should be in control. That's the thinking behind the Children's Online Privacy Protection Act and the COPPA rule. The rule has been in place for years, but the Federal Trade Commission, the nation's consumer protection agency, has revised COPPA to keep pace with technology. If your company has been complying with COPPA, the basics still apply. You still have to give notice to parents and get their verifiable consent before you collect, use, or disclose personal information from children under 13. You still have to keep kids' information secure. And the revised COPPA rule retains safe harbor provisions so that groups can submit programs for FTC approval. But 5 key changes to COPPA take effect July 1st, 2013. Here's what your business needs to know.
I'm Peter McGee, an attorney with the FTC. So what's new about COPPA? The first important change is that the FTC has revised some definitions to expand who's covered by COPPA and the kinds of information that require companies to comply with the rule. The rule has always applied if you operate a website, an online service, or an app directed to children under 13. It also applies if you have a site, a service, or an app directed to a general audience and you have actual knowledge that you're collecting personal information online from kids in that under 13 age group. Revisions to the rule make it clear that COPPA also covers an operator of a child-directed site or service where it allows outside services, like plugins or advertising networks, to collect personal information from visitors. In addition, if a plugin or ad network has actual knowledge that it's collecting personal information through a child-directed site or service, the plugin or ad network is covered by COPPA too. The upshot? The rule applies to companies that may be new to COPPA compliance. The FTC also has revised the definition of the types of information COPPA covers. The rule has always applied if companies collect certain kinds of personal information from kids under 13, like their first and last name, a home address, a phone number, an email address, online contact information, or a screen or username that functions as online contact information. But the FTC has clarified that definition. The COPPA rule covers geolocation information that can identify a street name and the city or town. And we've expanded the rule to include photos, videos, and audio files that contain a kid's image or voice as well. Something else covered under the revised COPPA rule: persistent identifiers that can be used to recognize a user over time and across different sites or online services. But there's a notable exception here. COPPA's parental notice and consent requirements don't apply if the identifier is used just to support your site's internal operations. Take a look at the rule for more about the meaning of internal operations in this context. Another change to COPPA relates to what operators need to tell parents. It's still the law that you have to notify parents directly and get their verifiable consent before collecting personal information online from their kids. But now you need to know to put certain key pieces of information up front within the notice you send. You'll want to read the rule for the specifics, but the big picture is that it's not enough just to give parents a link to something on your site and expect them to figure things out for themselves. This change will make it easier for parents to get the important details they need when they need them. The rule also streamlines what you have to include in your online privacy policy about your information practices. The third change involves new ways to get the parental consent COPPA requires. In addition to the methods already in the rule, including FTC-approved safe harbor programs, COPPA now gives businesses more ways to get a parent's okay. For example, electronic scans of signed consent forms, video conferencing, the use of government-issued IDs, and alternative payment systems, assuming they meet the same stringent criteria as credit cards. The sliding scale mechanism of parental consent, often called Email Plus, is still an acceptable method for operators that collect personal information just for their own internal use. Technology changes quickly, so to encourage innovation in this area, the revised rule sets up a voluntary process for businesses to get FTC approval for other methods of parental consent. The fourth change strengthens provisions for keeping kids' information confidential and secure. Under the revised rule, operators must take reasonable steps to make sure that before releasing information to service providers or other third parties, those companies are capable of maintaining the confidentiality, security, and integrity of the information. It's not enough if they just talk the talk. You also need to get assurances they'll follow through. Under COPPA, you can retain kids' personal information only as long as it's reasonably necessary, and when you dispose of it, you have to take reasonable steps to protect against unauthorized access. The fifth change to COPPA deals with additional monitoring of self-regulatory safe harbors. The new rule strengthens the FTC's oversight of safe harbor programs. It requires them to audit members and report the combined results of those audits to the FTC every year.
That's just a brief recap of changes to COPPA. For compliance resources, visit the Children's Privacy page on the FTC Business Center at business.ftc.gov. For more how-to guidance, read the Children's Online Privacy Protection Rule and Complying with COPPA, Frequently Asked Questions. Have a question that's not answered there? Send us an email at coppahotline@ftc.gov.
Okay, now that we're back, let's talk about video game ratings and the First Amendment. And the case I gave you to look at is the U.S. Supreme Court case Brown versus Entertainment Merchants, decided in 2011. And the issue in this case was a statute in California that was attempting to require, as a matter of statute, that video game makers include specific kinds of warning labels on the video game packages. And the rationale for the legislation was that video games can be very violent, and the legislature cited some studies suggesting that the violence of video games can have a negative impact on children who play video games. So it was cast as a child protection measure. And as you can see, the Supreme Court decided that this statute was unconstitutional under the First Amendment. And an opinion which might surprise you a little bit, written by Justice Scalia. And I think there's an interesting tension as you look at Justice Scalia's majority opinion and you look at Justice Thomas's dissent. The two originalists on the court really took different views about what the original meaning of the Constitution was, and that really influenced the way I think the different coalitions of justices lined up ultimately in deciding this case. So a first key thing that you need to note is that the court clearly unambiguously says that video games, like any other kind of speech, qualify for First Amendment protection. So there had been some arguments that video games is a certain kind of entertainment, is more interactive, perhaps doesn't qualify for the same kind of speech protection, and the Supreme Court says no, video games clearly qualify for First Amendment protection. Justice Scalia says in this majority opinion that speech about violence is not considered obscene speech under the First Amendment. Now, why is this an important finding? It's not as though obscenity can be sort of necessarily flat out banned by government under the First Amendment, but as you know from constitutional law, there's a long line of cases dealing with obscenity and pornography in the First Amendment context. And the Supreme Court has recognized that there are circumstances in which a government may have an appropriate interest in regulating obscenity and pornography, and in particular, that interest becomes very strong when the regulation relates to the protection of minors. So there are cases about suggesting that pornography itself can't be simply banned. It can be regulated under certain kinds of circumstances. Child pornography can be flat out banned. So there's Supreme Court case law talking about that. Similarly, obscene speech, or so for example, a television show depicting sexual act or something like that that's short of pornography, perhaps, can't usually be flat out banned. It can, under some circumstances, be regulated, and in particular, as that kind of content is made available to minors, it can be regulated. But by making this move of saying that speech about violence is not obscene speech, that whole line of cases is taken out of play. And ultimately, Justice Scalia decides that strict scrutiny has to be applied to this statute involving protection of minors and warnings on video games. As you know, very often, probably more often than not, when strict scrutiny is being applied, it's very difficult for a statute to pass muster. And this statute ultimately does not pass muster in the eyes of the majority. So notice Justice Scalia's way of approaching the question of how the First Amendment should be interpreted in relation to speech about violence directed to minors. And he's consistent with the way he interpreted the Constitution. He would look at historical tradition of how a particular kind of area of conduct was understood, and particularly understood at the time of the framing of the Constitution. And he says there's no long-standing tradition about concerning speech about violence to minors. In fact, he says there's many examples going back to the old fairy tales that show that minors are often exposed to violence in the literature that they're exposed to. And Scalia doesn't buy the argument that video games are different than Grimm's fairy tales or something like that in a material way. Even though video games are more interactive, you're playing the game, you're more immersed in the game, Scalia said this really doesn't make any difference in terms of the First Amendment analysis. It's all a form of speech, it's all a form of literature, and it's not inconsistent with the fact that children historically have been exposed to violent imagery in the literature that they're exposed to, and this was always considered a part of the sort of speech that the First Amendment would protect. Now, there's an interesting concurrence by Justice Alito joined by Justice Roberts, and if you notice, Alito says, well, I agree with Scalia insofar as this statute is very vague. Its definitions about what would fit into different categories of violence and have to get a different kind of rating is too vague, and that's a problem. But Alito says video games are different. Video games are interactive. A player of a video game is much more immersed. The player is actually carrying out some of the conduct through the player's avatar or character in the game. And the violence in the games can be very extreme and intense and graphic. And I think, those of you watching this lecture who are or have been gamers who have played first-person shooters or other games like Grand Theft Auto, other games like that, that there's a fair amount of truth in what Alito was saying. Even though it is, you're playing a game, it is stylized in many ways. Still, games can be pretty graphic, and you are playing. And so, Alito says he's not willing to say one way or the other how this would turn out if a statute were more narrowly drawn. He just wants to flag this issue and suggest that it's possible a more narrowly drawn statute could survive because of this concern that video games are different. And then you have Justice Thomas's dissent, and this is this place where it gets interesting, and you actually, I think, on a fair amount of occasions you saw Thomas and Scalia disagreeing on their approach to originalism and their interpretation of original meaning. And Thomas says the original meaning would be that no one can speak to a child without going through the child's adult parent or guardian. So at the time of the framing, Thomas says you wouldn't simply go up and speak anything to a child without going through their parent or guardian. So an interesting bit of historiography, whether it's accurate or not, I don't know, but it kind of raises a difference in how they would have approached it. But of course, core takeaway for us, majority opinion, video games are speech, and video game violence is not in the category of obscenity when it comes to First Amendment analysis. How does this all play out? I mean, if you do play video games at all, you'll know that they do have warning labels on them, and I have up here on the screen what those warning labels look like. I do know as a parent, now my two of my kids are older, or in their 20s or almost in their 20s, so this isn't really a place where I get involved anymore, but with my son who just turned 15, I do get involved here, and I am concerned if he wants to buy a game that has an M label on it. I'll look very carefully at what that game contains, and more likely than not, I'll not allow him to buy it or steer him away from it. But how does this work now? It is entirely voluntary. So the ESRB, the Entertainment Software Rating Board, is an industry organization that has come up with these labels. Why does the industry do this? Partly a public relations measure, partly an effort to stave off other legislation, whether at the state level or nationally, that might be drawn up more narrowly in an effort to avoid a constitutional problem. Also not an issue I think that the industry, even if they end up winning it, really wants to be seen litigating. So you can ask about whether these labels are really effective or not, but this is the system we have in place now. Okay, so let's move into this topic of the Digital Millennium Copyright Act and virtual worlds. And we're talking about the Digital Millennium Copyright Act here. There are a number of pieces of the DMCA, and as we have seen, we've spent a fair amount of time looking at cases involving the notice and takedown provisions and red flag knowledge and so on under the DMCA. So that's kind of one portion of the DMCA. Another portion of the DMCA relates to technologies that protect access to a copyrighted work. Really I think the design or the intent or understanding when this was passed was to protect encryption. that protects access to a work. So think about a DVD or a Blu-ray that you might have. If you drop that thing into your computer and try and burn a copy of it, you can't just do that. It's protected by encryption. The whatever software you're trying to use to burn a copy will not be able to get at the underlying code and decipher it and burn you a copy. The only way you could do it is if you have a piece of software that cracks the encryption. Now, this is actually not that hard to do, certainly not with the kind of encryption that protects DVDs. Some kinds of encryption schemes are harder to break, some are less hard to break. But what this part of the DMCA does is it says that cracking or breaking that kind of protection measure can itself be an offense. Now, this is not an offense under the Copyright Act. It's under the DMCA, which is really, if it's examined, I suppose, passed under the Commerce Clause, not under the Intellectual Property Clause of the competition, but nevertheless a federal statute. And then there's another piece of the statute that talks about trafficking in the technology, in other words, distributing technology that allows this kind of encryption to be broken. So the classic case is DRM, digital rights management, some kind of encryption scheme on something like a DVD, and a program that when you drop that DVD in your computer and want to burn a copy, this program allows that encryption to be bypassed or broken, and you can burn a copy of the program. That's the classic case. In virtual worlds or video game worlds, it can be a very interesting thing, because if you think about some of these games, and the case we have to look at is a Ninth Circuit case involving the game World of Warcraft. Some of these are persistent, massive multiplayer games. And as you're playing the game, you're building up the levels of your character. Your character's getting stronger, your character's getting more treasure, more weapons, more power, and is able to do more and more as you advance through the game. So the early stages of the game, you have a character that is not very powerful, that can be killed very easily, and it's hard to kind of take the time to level up and get to that level where you have a higher performing character. Well, one of the ways that you can do this, and there's actually a market for this, you can hire someone to play the game for you and get through those early levels. That's one way people do it. But another way people do it, is they buy characters. So people will play the characters, level up, and then sell their passwords and so on in an online forum, so you can buy the character. Another way is you can use a bot. So you can actually use a piece of software that will go online for you while you are not personally online, and automates the playing of the game and automates the leveling up of the characters. And this is what this glider software did in the World of Warcraft game. So as the quote from the case here indicates, you kind of tell glider what to do, and then it will automatically do it and allow you to level up. Now, obviously, the creators of the game don't want you to be able to do this for a whole bunch of reasons. One is, it affects the integrity of the world, the integrity of the game. The notion is you're supposed to be able to kind of level up and advance in the game as you get better at it. It's kind of a reward for getting better, and so the idea is this affects the whole integrity of the game. Some of these games actually develop kind of secondary economies. So there's some degree of buying and selling of equipment and goods and the like that is legitimate within the game. Very often the games allow you to buy equipment and goods and other things as in-game app purchases, and so the manufacturer of the game is also making money through that. So there's a number of kind of gameplay related reasons, community reasons, and economic reasons why the manufacturer of the game may not want you to be able to use something like this. For those of you who haven't seen Warcraft, here's just a real brief piece of the trailer for the game. Rated T, as you see.
scream. Claim your destiny. You will all be conquerors. And what, Gul'dan?
So you get a little bit of a sense there of the sorts of kind of humanoid character monsters that are going on and the things you would do. So what ends up happening is Blizzard, the maker of this game, first of all, has a prohibition in its terms of service against using bots. So if you are a player and you're signing up for the game, you click I agree to the terms of service, and you represent you're not going to use a bot, and you can get kicked off the site if you're caught using a bot. So they have that, but they also have a technology that they're using to try and detect and eliminate the use of bots that Blizzard calls its Warden Technology. So the first thing this technology does is when you log on to the game and boot up the game, it scans your computer's library of DLL, Dynamic Link Library files. These are files that allow apps and programs to communicate with each other and with the operating system on the computer, and they will have specific signatures, or they can have specific signatures relating to different kinds of programs. This is the way, for example, virus technology works. In part, it's looking for DLLs relating to viruses. So the Warden technology is scanning, looking for DLLs that are identified with bots. Now, very cleverly, the Glider program, the program at issue, the bot program at issue, is reconfigured by the maker of Glider to not load until after the DLL scan is complete, which means that the DLL scan is not going to pick up Glider through this method. The other thing that the Warden program does is it's going to scan the user's computer while it's connected to the World of Warcraft servers, and it's going to look for certain patterns of code related to known bots or cheats. So again, it's kind of like a virus scanner. This isn't a virus, right? But a virus scanner will do a similar thing where it's looking for DLLs, it's looking for certain patterns of code, it's looking for file names, other things like that. Again, if there's a match, the player is booted from the game. So what happens here? First question, is the maker of the Glider software liable kind of out of the gate for secondary copyright liability? Right now, the maker of the Glider program is not itself infringing directly on any copyright in the World of Warcraft game. It's not. They're not downloading the game. They're not making a copy of the game. They're not redistributing the game. But they are allowing the player and facilitating and encouraging the player to download and run the game, which requires a copy of the game to be made, or at least parts of the game to be made on the local computer, in a way that violates the terms of service. So is that encouragement to violate a terms of service equivalent to an encouragement to commit copyright infringement by the user, by the player? And if it is, that's potentially a contributory or vicarious copyright infringement. But the court says it's not. And it's not because, and it looks carefully at what a terms of service is. So first of all, the WoW players, the users, are not owners of the game. They're not owners of the software. They're licensees under the license. But the terms of the license that relate to bots are, the court says, contractual covenants, not contractual conditions. Why does that make a difference? If it's a contractual condition, which might be, for example, you pay a monthly fee to be able to continue to use the software. All right. So as a condition of being able to use the software at all, you pay the fee. If you don't pay the fee, you don't have a right to use the software. If somehow you're finding a way to use it anyway, you're making an unauthorized copy, that's a violation of a contractual condition. You're not protected by the license, you're infringing copyright. But a covenant is something different, and the remedy for violation of a covenant is not a copyright infringement claim, but it's a remedy relating to that covenant, whatever that remedy might be. So for the individual user, they're at best violating a contractual covenant, which means that the maker of Glider potentially could be liable maybe for something like tortious interference with contract, but can't be liable for secondary copyright liability. All right, now the court moves into the question of the DMCA. You might ask, well, wait a minute. The court has just decided there is no secondary copyright liability. This is not, and even a user using Glider is not infringing copyright. At best, they're violating the contractual terms of service. Why are we moving on to the DMCA? Doesn't the DMCA involve encryption and related technologies that protect access to a copyrighted work? That would be a very good question. And in fact, that's one of the issues that's litigated and decided here by this court in a very interesting, perhaps controversial, and I think really potentially wrong way. But nevertheless, this is the decision in a very important circuit, obviously the Ninth Circuit, involving law relating to video games. So here's what the court says. The DMCA, the part of the DMCA we're talking about, the anti-circumvention and anti-trafficking provisions, create two kinds of claims. One is circumvention of a technological measure that effectively controls access to a protected work, and a copyright owner is able to enforce that prohibition. The second is trafficking in technology that circumvents technological measures that effectively protect a right of the copyright owner. So notice that the first bullet there, circumvention, has to do with control of access. The second bullet has to do with a right of a copyright owner. The court, the Ninth Circuit, says that the anti-trafficking provision goes to the exclusive rights of copyright, whereas the anti-circumvention provision does not. In doing this, the Ninth Circuit rejects the reasoning of the Federal Circuit in different cases involving this same legal issue, where the Federal Circuit said both the circumvention and trafficking provisions require an infringement nexus. The whole structure of the DMCA only makes sense, the Federal Circuit said, if anti-circumvention relates to then breaking in and getting access to do something that would infringe copyright. The Ninth Circuit says no. The technology is protecting access to the copyrighted work. But if you break the technology and are doing something else that isn't infringing copyright, like facilitating a breach of contract, you've still broken that technology that still violates this provision, this section of the DMCA. So then the Ninth Circuit, and that's a pretty controversial, I think personally incorrect holding, but there it is in the Ninth Circuit. The court then goes down and says, all right, what exactly happened here? Does the Warden Technology really effectively control access to the work or not? And so first of all, as to individual literal or non-literal elements, like a specific character if they're copyrighted, or a specific storyline, or a specific sequence of images, the court says it doesn't protect that. It is not an encryption scheme, right? It's not like the thing that doesn't allow you to copy a DVD onto your computer. So it's not doing that. But the court says as to the dynamic non-literal elements, whatever those are, and I assume it means sort of the entire gameplay, like the feel of the gameplay, the Warden Technology does, in some sense, control access to that. Again, I think this is really a problematic holding, but there it is in the Ninth Circuit, and therefore the court says on that basis the permanent injunction that had been entered in the court below against the Glider Technology can be affirmed. One other piece of this, even having reached that holding, the Ninth Circuit goes on to talk about the trafficking claim, and here the court says, no, there is no violation of the trafficking provision. because the Warden Technology does not prevent copyright infringement. That's not what it's about. It's about policing things that are really violations of a terms of service. So, real interesting opinion. As you can see, already a circuit split with the Federal Circuit. I don't know if this issue is important enough yet, to even with a circuit split, to get up to the Supreme Court, but I think it's a very interesting, and it will have implications as we try to continue to apply the DMCA and these circumvention provisions to video games and virtual worlds. All right, moving quickly into our next topic, which is the in-game use of trademarks. Now, when we're talking about the in-game use of trademarks, again, if you're a gamer, I think this will in some ways be familiar to you, especially if you play sports games, car racing games, games like that are designed to be at least somewhat closer to events in the real world. You know, certainly a sporting game. I love to play FIFA soccer. I play with my son, and I play online sometimes. And obviously, FIFA itself is a trademark, and you have the Adidas soccer ball, or the logos, the advertising billboards on the stadium, all those sorts of things. Now, with a game like that, or an auto racing game, I used to play a game called Paradise City, which I really liked. You're racing a car, through city, you're crashing through barriers, you're doing jumps. There would actually be billboards on the street with real advertisements on them. Now, how does all that work? Well, those sponsors generally are happy to have their stuff placed in the game, and in fact, there's a whole industry of product placement in video games, just like there is a whole industry of product placement in the movies. So that's one thing that's generally going to be all authorized and dealt with through commercial contracts. What we're talking about here is games that are in some way using a real or somewhat stylized or modified trademark in the context of a storyline without it being a product placement and without having permission to do so. Now, I think general rule, right, if you're representing clients that are working on video games or some kind of interactive game, I think fair advice to give them, don't use a brand name, don't have a brand name appear in the scene, and don't use a brand name unless you have permission to do so, unless it's a product placement or you otherwise have permission to do so, because it's likely to lead to a dispute. But as this case we're going to look at now, Mil-Spec Monkey v. Activision, illustrates, and as some of the other cases talked about in this case illustrate, it may not be trademark infringement, and it's going to relate to how the brand is used in the story. So Mil-Spec Monkey opens up a whole world that I didn't really know about until I read this case. Now, I knew about the Call of Duty games. My boys love to play the Call of Duty games, much to my chagrin. And these are somewhat realistic games involving soldiers and a variety of scenarios fighting each other. What I didn't know about, and I knew within these games you can, as you advance, you can get special patches that go on your character's uniform for certain achievements. I've got on the screen here a screenshot showing the initial patches you can get in the Call of Duty Ghosts game that was at issue in this case. What I didn't realize is this is actually a part of sort of military and paramilitary culture, that not just your unit patch, but sort of other patches for morale and other events like that are available, and that there are retailers that are selling these kind of things, and that they become popular kind of in their own right for a variety of purposes. So Mil-Spec Monkey is one of those retailers. Here is what apparently is a relatively famous patch called the Angry Monkey, and this is that patch from the Mil-Spec site. Here is the Angry Monkey as it appears in the Call of Duty Ghosts game. I'm going to pause for just a moment here and show you a brief clip of where those patches are in the game. You'll see how they appear and how briefly they appear, but where they are in the game. So I'm going to show you that for just a moment, and then we'll come back.
Now it takes you here. You can go to gender, headgear, uniform, patches and background are where they are. So patches, I'm just going to go ahead and start here, show you guys all the patches. Now I'm not going to read to you guys what all of them do. I will scroll over every single one of them like this so you guys can see. All these ones are standard issues, as you can see right here. So these are all standard issue here. Now I'm going to go to the next one and just scroll over so you can kind of read them like this. And I'll assume you guys are going to be reading these as I scroll through them, and you can pause it at any given time.
Okay, so what does the Northern District of California, again, as is not surprising, an important district court for disputes involving video games, what does this court say? Well, first of all, Ghosts as a video game, Call of Duty Ghosts, is entitled to First Amendment protection. Within a setting in which there's a work that's entitled to First Amendment protection, the trademark owner can't control public discourse about the mark if the mark is being used for something more than a source identifying function. So, here's an example. I'm doing this video with you in this class. I'm holding up here a bottle of Poland Spring water. Poland Spring is a trademark, a brand name for this water. Now, this video is entitled to First Amendment protection. It is not a trademark infringement for me to be using this in this way to make this point in this academic setting. There is a doctrine of trademark fair use. That's effectively what's going on in this mil-spec monkey case. Now, if I were to say, do a commercial for Poland Spring, and maybe just change the name a little bit and call it Newark Spring, right? And do a commercial. Well, that's a commercial. I'm trying to sell something. That's a source identifying function. That's the kind of distinction you want to think about. So the mil-spec court says applies a test from the Second Circuit, the Rogers test, and says, well, if you're not using it for a trademark, for a source identifying function, and it's in the context of First Amendment speech, it will not violate the Federal Lanham Act, which is the federal statute involving trademarks, unless it has no artistic relevance, or it has some artistic relevance, but it will explicitly mislead. And here the court says there's no way that's happening. Nobody thinks, or the court presumes that nobody's going to think that mil-spec is sponsoring Call of Duty, that Call of Duty is selling mil-spec stuff or selling competing stuff. It's a patch used in the game. Now, I think you can see the logic of that. Even there, as I say that, right, no one will think mil-spec is sponsoring that game. No, I don't know. Maybe not. But nevertheless, here's just one holding from one court, one trial court on this issue. It's an issue you want to be aware of when you're thinking about trademarks in video games. Okay, the last topic we'll talk about in this lecture, the copyright status of video game characters. So to think about this, we need to do a little bit of background on copyright in characters. Now, we've talked broadly throughout this module about copyright in general, and remember that copyright protects original expression. Copyright doesn't protect ideas. There's an originality requirement. That's not a novelty requirement like patents, but it means you have to have yourself, the claimed owner of the copyright, yourself have come up with this expression, and it has to have, some degree of creativity and originality, a minimal degree. And one of the places that this can be a tension is, well, are you doing something that you have some degree of creativity in, or are you just taking things out of the public domain? So if I wrote a poem and the first line is, half a league, half a league, half a league onward, into the valley of death rode the 800. Well, I can't claim copyright in those lines because those are famous lines. And it's not because they're famous, but they're lines from the Charge of the Light Brigade, which is I think 19th century poem, right? It's an older 18th century, I'm not sure exactly when, but an older poem, right? So if you're taking something out of the public domain and just copying it, or close to copying it, right, you may not have copyright protection. And that's the problem we have with characters, because We don't want copyright to take the stock of potential literary characters out of circulation. So think about these two characters, star-crossed young lovers from different families. The families are separated by political, cultural, or religious tension. Despite that tension, these star-crossed young lovers meet, they fall in love, and one of two things happens. Either they wonderfully unite these families and overcome their differences, or tragedy ensues and they end up dying, right? Romeo and Juliet, other kinds of stories like that. You can't take that general description of the character out of literature. That's not what copyright's designed to do. But if the character becomes more specific, and one of the tests courts use is if the character is sufficiently delineated. Another test some courts use is the character really the heart of the story being told? A classic example in copyright jurisprudence is Superman. Superman, now of course, some kind of hero with powers of great strength goes way back to, Greek myth and Hercules and so on. But that particular character, having come from the planet Krypton, wearing the particular kind of costume that he wears, doing some of the particular things he does, that's one that, and it's recognizable, it's kind of iconic, right? That kind of thing might be protectable as a character. Well, you can see how this can get really difficult. So let me show you a few iconic characters in recent film and literature. Here's one of my favorites, Gandalf, right, from The Lord of the Rings and The Hobbit. So this, wizard character, he's got the gray beard, he's got the staff. Well, we can compare that to Dumbledore, another one of my favorite characters from Harry Potter. Now, Dumbledore doesn't have a staff, but he does have a wand, right? And the staff and the wand are in many ways similar. They're kind of the locus of the way the wizard channels his power. They're both wizards. They're both sort of high up in their wizarding order. They both have the long gray hair. They both have the long gray beard. They both have sort of constant expressions of knowing, wisdom, right? Those sorts of things. There's a lot of similarities between these characters. Are either of them protectable? Well, are there other characters that they're derived from? Well, here's one. How about this one? The long white beard, the hat, the staff. What is this character? This is Odin the Wanderer. And in fact, Odin the Wanderer is a literary character that Tolkien used to create Gandalf. So, are there elements of Gandalf that make him sufficiently delineated to be protectable in some way? Are there elements of Dumbledore that make him sufficiently delineated to be protected in some way by copyright? Maybe, but there are certainly elements that are not. I mean, you could do a movie or a story of a wandering wizard with a white beard and a staff or a wand wearing a robe, and that couldn't possibly violate copyright in itself in Dumbledore or Gandalf. All right, so that's general frame of the issue. Here's what happens in this Blizzard Entertainment versus Lilith Games case. Again, notice Northern District of California. What you have is just an opinion on a motion to dismiss. Blizzard claims copyright in its World of Warcraft characters, the same game we looked at just a moment ago, and the defendant allegedly copies some of those characters in games for mobile devices. So I gave you the complaint and the answer and the exhibits, and I just wanted you to take a look at the way it's all framed and look at some of those exhibits. So here's just a couple of examples. You can see from the complaint, the plaintiff's works, defendant's works, this Kung Fu Panda bear with the hat, with the staff, right? Those kinds of details. Here's one of the characters that I think we saw in that original clip, right? These kind of bull-type characters with the club or sword or axe, and here's one from the defendant's game. And I think when you look at those, you can certainly see the resemblances between those. The question is going to be, are these sufficiently delineated? Are there other characters like this? I said Kung Fu Panda, right? The Disney movie Kung Fu Panda. Are there other sort of versions of the wise Kung Fu warrior that might be an animal like a panda? This kind of bull character, does this go all the way back to bull characters even in Greek mythology or other mythology? How does all that relate? Well, what happens in the opinion that you have is that the court dismisses the original complaint on a 12b6 motion, really because the court said, I don't think this complaint is pled with enough specificity, but the court gives leave to amend. An amended complaint is filed, and there's a subsequent motion to dismiss the amended complaint, which is decided without an opinion, and the court says, well, now it's been repled with enough specificity, allows the case to go forward, and the litigation is now pending. There were some discovery, I looked at the docket, there were some discovery disputes, there was some issue about potential alternative dispute resolution, but it's an ongoing litigation. So, there's an interesting example where perhaps you look at these characters and say, yeah, they're similar, but, I can identify characters in other kinds of literature and older literature that these are in many ways very similar to him. And I think this, the Minotaur is the creature I was thinking of from Greek mythology, was certainly what this is drawn from. It's even called Taurin, Minotaur, Taurin, Taurus, the bull, right? It'll be interesting to see how that develops. But meanwhile, it's an ongoing litigation, which is expensive and which can be kind of difficult to get out of. So this is another area, I think, that is going to be sort of continually developing, this area of the copyrightability of video game characters, how those characters spill over into related media, like from console to PC games to handheld games to other properties like books and movies and television shows, and to a variety of other ways. So this is the end of our kind of rapid summary of a bunch of different areas relating to new media and video games, and I will see you in class on Thursday.